Hey, good morning, everyone. I'm Chris Parker. This is Kristen Ishihara with the Ishihara and Parker Law Firm here in Longview, Texas. Today, we're going to be talking about a certain type of trust, an irrevocable trust. And amongst those trusts, we're going to be talking about a certain type of irrevocable trust, which is ones that are made for protection from government benefits, basically, or compliance, such as a Medicaid compliant irrevocable trust. Kristen, what are we talking about? Yep.
Primarily, what we want to talk about today is what we would refer to as a Medicaid asset protection trust. So, a lot of times, clients will visit us and say, "Hey, I know I need to get things out of my name. There's a look back period. Can I gift stuff to my kids?" The answer that we typically would give someone is no, you shouldn't gift something to your children and put it in their name. You may have the best kid in the world, but that kid could pass away. That kid could be in a car accident and incur their own debts. They could get divorced. So the way to protect those assets is not by taking them out of your name and putting them into a kid's name. Now, what is the solution? A lot of times we're able to offer to clients an opportunity to use what's called an irrevocable asset protection trust. There's some pros and cons to these that we want you to be aware of. It is not the solution for everybody, but if you do have countable assets, it is an option that you might consider because Medicaid will obviously count some of your assets. And if those assets, you want to shield or protect those assets, they do need to be out of your name for 5 years before you would need Medicaid. So, who would this be appropriate for?
Well, I mean, the typical client that I've at least seen consider it are those that have assets that we know would count for Medicaid purposes. So usually people with rent houses having more than one primary residence, they definitely consider it. Sometimes people with multiple mineral interest or royalty interest would also consider these irrevocable trusts. If we're talking about assets and how they're held, we know that your non-qualified investments are a bit of a problem. So if you're a first person who's heavy on 401k, IRA, maybe it's not right for you. But instead, if you are heavy in the assets that count, which would be non-qualified investments, those folks look at it and say, ooh, I would like to shelter or at least consider sheltering those assets from the government.
Sure, and there's a tipping point, right? So if you have $2 million in investments, you're probably going to opt to privately pay for the care that you need. The trust that we primarily are talking about is going to be, it would be difficult for that person to privately pay for an extended period of long-term care. So what that means is if you needed skilled nursing care, that's probably, at least here in East Texas, $5,000 to $6,000 a month. Would you be able to sustain that for an extended period of time? And then you're balancing what assets you want to preserve for your beneficiaries but put out of your reach. So at some point, if you have a significant amount of assets, you're going to choose to privately pay for that care, and this is not the best tool for you. If you have rent houses or other things that are not liquid, this might be a great tool because those additional properties, or maybe you have inherited family land that's just very important that you keep in the family. If it's not your residence and it's real property or land, it's a countable asset that will likely mean you can't get Medicaid, but you can't use it to pay for the facility. So sometimes that's a good reason too. If you have a large number of CDs or other things in the bank, a lot of times people have set that aside and they've put, I want grandkid A to get this, I want grandkid B to get this, and they've set aside a certain amount of money. Those are all going to be countable assets if they're non-retirement. So they would be subject to Medicaid counting them and potentially having to be spent down for your care before you could receive Medicaid benefits. So there is kind of an in-between client where this is appropriate.
Yep.
It is not for you if you want to use the asset. So the trick, with this asset protection trust is once you move the asset into the trust, the terms of the trust say you cannot touch the principal of the asset. It no longer belongs to you, and you under no circumstances will spend or use the principal.
Yeah.
Now, you can continue to manage it or use it to benefit other assets in the trust, but let's just say, for example, I put in a $100,000 CD into my asset protection trust. I can be the income beneficiary of that asset, so it generates $4,000 a year. I'm allowed to receive that as income, and I use that as I see fit, but I cannot use the $100,000, period. I've set it in the trust. Pursuant to the terms, I've said I'm not going to use it. That's why Medicaid would not count it against me in the future because it's not available to me as a beneficiary.
Yep. And, and just talking about who this is right for or wrong for, it's hard for us to say for sure. I have seen some people who really express interest in these are those that have greater needs in their own, I guess I'd say. I've had some folks that'll have like disabled children, or at least children I know who are going to struggle really hard. And sometimes they'll say, hey, you know what? No matter what, I want to ensure this person or this child receives those funds. I've had a few wartime veterans come back quite angry, and they were like, I don't want the government to get a dime. I mean, these are useful tools for the right purpose, but what Kristen just told you is very important. The income is still yours, but the principal no longer is, and that's a hard decision to make. Suddenly you have $100,000 and now you don't. The trust owns it. It's not like the revocable trust. This is a different animal. And so it's really a decision to be thinking about, because my favorite part of it, besides the income versus principal, is the irrevocable part of it, right? This isn't a wish-washy kind of thing. You are making decisions about what's in and what's out that are binding, right? And you're also making decisions about who's benefiting and who's not. And that is also binding. So these are not things that we willy-nilly do. It is a useful tool. We're lucky we're in Texas and we can use these tools, but think twice in how you see your future playing out.
Sure. So Chris's point is that you cannot change the beneficiaries once you've put it into the trust. So if you are a blended family, not a good tool for you. If you like to change your will every 6 months, not a good tool for you. Once you put it in there, what's specifically irrevocable is you cannot change who you've listed as the beneficiaries in an irrevocable trust. You cannot change it.
Yep.
Now, you're going to reserve the right to change the trustee. So if you needed to update that, then that's fine. But using this tool, you need to really consider that the asset is not available to you to use, and you cannot change who it goes to. So if you've been married one time and have 2 kids and you're never going to change that, might be a good tool for you. But if you would ever change your will to change who gets stuff or have a blended family, I would say usually not a good tool for you to use.
Yeah, and single folks who come in and say, I have no kids, I have this pile of money, I want to take care of my nephew and niece. I'm like, whoa, I got it, but let's just think about this. In this particular case, they're not disabled. You love those nephew nieces, but they're still not your children per se. Who comes first? And if the thought process is like, well, they'll get what I don't use, okay. If on the other hand, it's no, they truly need to come first. Those are just a fork in the road that I always try to explore, because I think it makes a difference.
Sure.
Yeah.
The other thing to know is that this is specific to Texas conversation. So Texas does not currently allow a self-settled asset protection trust. That's why these rules are the way that they are. So I can't set up a trust that I'm still the beneficiary, the principal for, and make it not attackable by my creditors. Maybe in the future that would change. Those are legislative things, and they get proposed to change. So this is, in Texas currently, the rules on how it would work if I wanted to shield it for long-term care. But in our business, primarily what we're using this for is if people come to us and say, I want to know how to protect these assets for my beneficiaries from long-term care. So kind of the highlights that I think you would consider if you wanted to use this tool would be, am I ever going to apply for Medicaid? Do I have enough assets where I'm going to just choose to privately pay anyway? Or is it possible, based on my medical condition, family circumstances, and other things, that I may need to apply for Medicaid? And in doing so, I want to preserve or shield these particular assets, land, minerals, cash, for my beneficiaries. And I'm okay with not having access to those in the meantime, as well as not being able to change my beneficiaries. You also need to have, go ahead.
Well, that's a great point, y'all. I mean, we don't know what the future holds. Obviously, we pretend we look at crystal balls and try to guess. If you have a family history of heart attacks at 65 with sudden death, I have other family members who come in and say, hey, my parents are still alive, or, and our Meemaw's, 97 and has had dementia for 10 years, and her sister had dementia, and family history plays into it. The folks that obviously I think should pay attention are those with family history that we know it's a known risk for something that will make us a strong body but weak of mind. Those who will live a long time but may not know what's going on and need that government assistance. Those are folks that I do try to, we don't know what the future holds. Hopefully it's a car wreck, heaven forbid. I'm just, you got to look at your family and say, hey, if we're long lived and mental health will be a concern, then that does something to consider.
Sure. Yeah. And then also considering what assets you have that you would want to protect in the trust. You don't have to put all of your countable assets in there either. That's a decision as well. So let's say you have 100 acres of family land that under no circumstances do you want to be sold. You can put one asset in there and keep out your cash, and then that is still available to you, and you use that. So you can use a combination of those things, but you can put into an asset protection trust any land. You can move a house in there that would allow your kids to sell it later and receive the other benefits of having a trust, including avoiding probate and those things. And then you can put in minerals, you can put in countable assets like CDs, cash, investments that are non-retirement, but just understanding what assets would need to go in there that would benefit you if you needed to apply for Medicaid. So if you use that tool, you would create that trust where you were the income beneficiary for your lifetime, and your beneficiaries, presumably kids, but whoever, were the principal beneficiaries, and then at your death, the trust would distribute to them, but the principal of your trust is only available to them during your lifetime. So they are the beneficiaries, but then it operates much like your estate plan. Once you move an asset in there, that is considered a gift as far as Medicaid is concerned. So it is subject to their 5-year look-back period. That's another thing to consider. Do I have 5 years? Because once you start it, that's your clock ticking when you fund the trust. If you later add things, that's a separate clock ticking for that asset, because the transition to the trust or transfer to the trust is the gift as far as Medicaid is concerned. But once it is in the trust, it is not owned by you, so it would not be reported on an application. And if the gift is more than 5 years in the past, then when you're asked if you've made a gift within 5 years, you say no.
Yep. Got to plan in advance for these. If you're already, heaven forbid, or in 97, this probably isn't the right vehicle for you, though it's up for you to decide. But yeah, age appropriate, health appropriate, asset appropriate.
Yep. And if you have any questions, please talk to an attorney about it. It's not the tool for everybody, but it can be a useful one if you have some of those circumstances we've referenced. So anything else?
Yep. Nope.
All right. See you next time.